Hi everybody. We are Group 1. Today we will talk about the general provisions on obligations, including concepts and grounds for establishment. Let's start with the definition of obligation. According to the Vietnamese Civil Code 2015, obligations mean acts whereby one or more subjects must transfer objects, transfer rights, pay money or provide valuable papers, perform acts, or refrain from performing certain acts in the interests of one or more other subjects. The subjects of civil obligation relationships are very diverse, including individuals, legal entities, organizations, businesses, states, or other entities recognized by law. The content of the obligation relationship is the organic, intimate connection between the civil rights of one party and the civil obligations of the other party. The scope of expressing the rights and obligations of the parties in an obligation relationship depends on the agreement of the parties or the provisions of law, and the objective nature of the relationship is always expressed. Obligations are always legally binding on all participating parties, stipulating certain actions that can or cannot be done according to an agreed agreement. If the relationship of obligation is violated, the state will have sanctions according to the law. The definition of obligation in the Louisiana Civil Code is quite different from Vietnamese Civil Code. We can see the structure of obligation in this provision consists of these elements. It must be a legal relationship, it's legally binding. There are two main subjects in which one party is the subject with the right and the other is the subject with the obligation, thereby distinguishing it from other types of obligations. Finally, performance may consist of giving, doing, or not doing something. In comparison to the Louisiana Civil Code, we can see some problems in the Article 274 of the Vietnamese Civil Code. Article 274 defining obligations as acts is unclear. It fails to indicate the nature of the obligation must be a legal relationship. The use of words and sentences in Article 274 of the Vietnamese Civil Code does not specify these three issues of obligations. First, is obligation a legal relationship? Second, will there be two entities or more in an obligatory relationship? And, do the objects of obligation include giving, doing, and not doing? According to the Louisiana Civil Code, besides the legal obligations, there are other types of obligations. First, is the moral obligation. Moral obligation has no legal effect, but merely emphasizes conscience. Moral obligation is quite common in life, such as ancestor worship. Another type of obligation is natural obligations. According to the Louisiana Civil Code, a natural obligation arises from circumstances in which the law implies a particular moral duty to render a performance. Natural obligation used to be a legal obligation, but it loses its bindingness. Therefore, the consequences of natural obligation, such obligations are not protected by law or are not coercive, but if the parties have voluntarily fulfilled the obligation, that performance is legally valid. The next thing we need to discuss is the types of obligations. The Vietnamese Civil Code hasn't specified this issue yet, but we can divide obligations into three groups based on its object. The object of obligation is what the parties impact upon in establishing and executing obligation relationships with each other. Article 276 of the Vietnamese Civil Code read that objects can be property, acts must be performed, or acts must not be performed. The acts must be performed is considered as the object of obligation if, from an act, multiple parties establish an obligation relationship wherein the obligated party must carry out the act according to the specified content. The act must be performed may be completed with a specific result, but it can also be detached from a result, due to agreements between parties or the nature of the act. On the other hand, the result of the act to be performed may be expressed in the form of a tangible object or may not, such as types of services. The acts must not be done is the object of obligation in cases where the parties establish an obligation relationship from that act, whereby one party has the obligation not to perform the act according to the specified content agreed upon by the parties. For the obligations with the object is property, Article 105 states that property comprises objects, money, valuable papers, and property rights. Recognizing that property is the object of an obligation means that the obligation can be a physical right. Property includes tangible objects. This conflicts with Article 274. In the Vietnamese Civil Code, one of the objects of obligation is property. This terminology differs from the Louisiana Code, which uses giving. The term property does not express the nature of rights and remit, so it should be replaced with an active property nature because the obligation itself is also a type of property, movable property. Specific objects in the form of properties, acts must be performed, or acts must not be performed are only considered objects of civil obligations when they meet the following requirements. They must provide some benefit to the entitled party. It must be defined or capable of being defined. The object of the obligation must be feasible. Now let's sum up by digging deeper to the nature of obligation. The nature of obligations, which is the right to demand, indicating civil obligations, has three important characteristics. Number 1, obligations is legally binding. Obligations are always legally binding on all participating parties, stipulating certain actions that can or cannot be done. If the relationship of obligation is violated, the state will have sanctions according to the law. This feature speaks of the legal enforcement of obligations and distinguishes them from natural obligations. It includes two elements, legal recognition and enforceable value. Number 2, obligations is a legal relationship. In an obligation relationship, the rights of one party are exercised through the obligations of the other party. If party A wants to receive benefits, it requires party B to properly and fully perform its obligations. Obligation is a human relationship, right to human rights. This feature shows that the bondholder's rights are only enforced against the bondholder and not on any specific assets, meaning that the bondholder can only request the bondholder to perform the obligation. Here it is necessary to distinguish between object rights and person rights. Number 3, the subject of obligations is determined. In a relationship of obligation, the subjects are predetermined individuals and groups. This relationship has absolutely nothing to do with people other than the identified subjects. In any situation, obligations and rights always go hand in hand and have a supportive relationship, meaning that one party's obligations will be the other party's rights and vice versa. Regarding the subject, rights over people have two types of subjects, the bondholder and the beneficiary. They are the people who determine each specific obligation relationship in which the bondholder is an active subject with the right to request the bondholder to perform a certain obligation. And the beneficiary is a type of negative subject who must perform obligations for the benefit of the bondholder or another person that has been specifically identified in a specific obligation relationship. The request and implementation of the request lead to different consequences for the assets of the bondholder and the beneficiary. For bondholders, obligations are the part that increases assets, asset. As for the beneficiary, the obligation is the part that reduces the asset, liability. To understand clearly, let's look at the example on the screen. In the goods trading relationship between A and B, the buyer A has the right to request the seller B to transfer ownership of the goods to A. So this relationship increases A's assets and reduces B's assets. On the contrary, B has the right to request A to pay for the goods for B. Therefore, this inverse relationship increases B's assets and reduces A's assets. In such permanent contracts, both parties have property interests in them. With this characteristic, the bondholder can only exercise his rights against the beneficiary, not on any specific asset. The exercise of the bondholder's claim depends on the existing or future assets of the bondholder. Therefore, if there is a lack of mutual trust, bondholders often require security of their debt by physical or personal measures, in which the physical security is dependent on rights, including pledge, mortgage. These subordinated rights allow bondholders to have priority over the specific assets used as security. If this property has been transferred, the bondholder still has the right to request a garnishment or confiscation and auction to collect the debt. However, the priority right to take debt on this property also depends on the privileges, that is, higher priority rights, because of the special nature of such rights of creditors. A personal guarantee is considered a guarantee, meaning that another person undertakes to perform the obligation on behalf of the beneficiary, if the beneficiary fails to perform his or her obligations. Let's move to part 2 of this video where we discuss the grounds for establishment to answer the question, where obligations come from. Article 275 of the Civil Code 2015 listed 6 sources of obligations. They are contracts, unilateral legal acts, unauthorized performance of acts, unlawful possession or use of or receipt of benefits from property, causing damage through unlawful acts, other bases as provided by law. Meanwhile, Article 1757 of the Louisiana Civil Code states that obligations arise from contracts and other declarations of will. They also arise directly from the law, regardless of a declaration of will, in instances such as wrongful acts, the management of the affairs of another, unjust enrichment, and other acts or facts. The Louisiana Code is organized more clearly. It separates the sources of obligation into two groups. The first one is the sources come from declarations of will, including contracts or unilateral acts, which means obligations depend on the parties of obligatory relationship. The second group of sources, which arise directly from the law, don't depend on the parties' minds. It includes wrongful acts, the management of the affairs of another, and unjust enrichment. The former group is known as judicial acts, and the latter is known as judicial facts. And that's all the sources of obligation. Now let's dig into each one. First of all, contract. What is the contract? Article 385 of the 2015 Civil Code states that contract means an agreement between parties in relation to the establishment, modification, or termination of civil rights and obligations. With this nature, when the parties agree to create, change, or terminate each other's rights and obligations, this will be the basis for forming obligations. Normally, the rights and obligations of the parties in a contractual relationship are symmetrical. The rights of one party are the obligations of the other party, and vice versa. Contracts give rise to civil obligations from the moment the contract takes legal effect. Although Article 275 of the Vietnamese Civil Code does not specifically stipulate, from a research perspective, the contract is the basis for arising obligations that must have legal effect. As for an invalid contract, the contract is not effective from the time of signing, so it is not considered a basis for arising obligations for the parties in the contract. So what is an invalid contract? The contract will be considered invalid if the contract has a purpose or content that violates prohibitions of the law or is contrary to social ethics. The contract is invalid due to falsification. Void contracts are established and performed by minors, people who have lost civil act capacity, people with limited cognitive and behavioral control, and people with limited civil act capacity. The contract is invalid due to a mistake. Contract is invalid due to deception, threats, or coercion. The contract is invalid because the person making it is not aware and in control of his or her actions. The contract is invalid due to non-compliance with formal regulations. When signing an invalid contract, the parties are obliged to return to each other what they have received, except in cases where the property that is the subject of the contract and the benefits derived from the contract are confiscated according to the provisions of law. This obligation arises from the provisions of law on resolving the consequences of an invalid contract. The second ground is unilateral legal. Unilateral legal acts are acts expressing the will of one party to create, change, or terminate civil rights and obligations. This is a type of civil transaction in which only one party's unilateral will is expressed. Therefore, whether a civil obligation relationship arises or not depends on the acceptance of this will by other people, those who will be the subjects on the other side of that civil transaction. Unilateral legal acts only give rise to an obligation when the will expressed therein does not violate the law and social ethics. At the same time, if the expression of that will is accompanied by certain conditions, then only when others comply with those conditions will obligations arise between the parties. In case a unilateral legal act has a foreign element, the establishment of validity and rights and obligations in that act shall be carried out according to the law of the country where the individual establishing that act resides or where the legal entity is established. Article 684 of the 2015 Civil Code stipulates unilateral legal acts involving foreign elements as follows. Next is performing work without authorization. According to the provisions of Article 574 of the 2015 Civil Code, performing acts without authorization is defined as follows. The basis for establishing the performance of acts without authorization can be determined based on the following factors. First, a person who performs a job without authorization is a person who has absolutely no obligation to perform that job but has performed that job. Obligations here are legal obligations prescribed by law or agreed upon by the parties. Second, the performance of that job must be entirely for the benefit of the person having the job. If the person performing the job is for his or her own benefit or that of another person, this regulation does not apply. Third, the person whose act is performed does not know or knows but does not object to the performance. If the person with the job objects but the other party continues to carry out the acts, he or she is not under this regime. However, the wishes of the person performing the acts must not be against the law or against social ethics. If there is no established basis for performing acts without authorization, this may give rise to legal consequences. Performing unauthorized acts is when one subject performs the acts of another. The subject performing the acts is completely voluntary, meaning the acts performed in this relationship is not a mandatory legal obligation. If the person performs the acts accidentally, unintentionally, or involuntarily, for example under duress or mistake, it will not be considered to be performing the acts without authorization. Between the person performing the acts and the person whose acts is performed, there exists no contract, no authorization. If there has been a previous agreement between the two parties, or if there is mutual consent, it is still considered a contract creation and is not considered to be performing acts without authorization. There must be established grounds to prove that the person is performing the acts, don't know or know but don't object. In case the person performing the acts is opposed but still continues to do it, he or she does not fall under this regime. At that time, intentionally continuing to perform the acts may be considered an illegal act, requiring compensation based on the provisions of Clause 7, Article 8 of the 2015 Civil Code. In addition, the performance of the acts without authorization can cause risks and result in disputes and lawsuits between the implementer and the person whose acts is performed. Performing work without authorization is the basis for a civil obligation relationship between the person performing the work and the person whose work is performed, in which the person whose work is performed is obliged to pay the remuneration as well as the reasonable amount that the person performing the work without authorization has spent to perform the work. However, if the person who performed the work neither requested payment nor remuneration, then the person to whom the work was performed does not have to perform these obligations. If a person performs a job for the benefit of another person, but that job is not in accordance with the wishes of the person whose job is performed, it will not give rise to the obligation to pay or remunerate the person performing the job. According to the provisions of Article 575 of the 2015 Civil Code, governs obligations of a person performing acts without authorization and also the obligation to compensate for damage. In Article 576, it governs the payment obligations of the person whose work is performed. The fourth ground is unjustified enrichment. It refers to material benefits obtained without legal basis. The receipt of such benefits does not necessarily result from the active behavior of fulfilling one's obligations, but can occur due to various reasons. The important point is that one person gains while another person suffers a loss. The gain of one person is the result of the damage borne by another. Enrichment can be derived from material or spiritual aspects. Forms of enrichment include increasing assets or economic benefits, preventing a decrease in value or assets, reducing their obligations, and enjoying a spiritual or intellectual benefit that can be valued in monetary terms. For the party suffering the loss, it may involve a decrease in assets, an increase in responsibilities or obligations, and the loss of opportunities that could have potentially increased the value of their assets. Obligations arising from unjustified enrichment include restitution, compensation, and payment. The principle is that anyone who possesses, uses, or benefits from assets without a legal basis and causes harm to another person has an obligation to make restitution or provide compensation to the injured party. Dependency or supplement. The arising obligations are of a supplementary nature. If there are other measures to handle the situation, priority should be given to applying those measures. There are two establishments of obligations in this case. The first one are cases of possession or use of property without a legal basis. The obligation to return arises only when the possession or use of the property is real and tangible. There are various examples, such as money deposited into an account, goods delivered and already in possession or use, etc. The second are cases of benefiting from the property without a legal basis. It means an increase in the value of the property or the enjoyment of benefits. This can be the appearance of new elements in the property, such as a sum of money deposited into an account, and at the same time is the disappearance of one or more elements in the debt property, such as a debt owed by oneself being paid by someone else. Harm to the property borne by others. Cause and effect relationship is the enrichment of one person is the direct cause of harm to another. Return of benefits and income. The beneficiary of property benefits obtained without legal basis must not only return the original property but also the benefits and income associated with that property, which governed by law in Article 581 obligation to return benefits and income. In the case of immediate possession or use of property, the beneficiary of property benefits obtained without legal basis is not obligated to return the benefits and income obtained during the period of immediate possession. Once the immediate possession ceases, the person no longer has the right to retain the benefits and income associated with the property. Causing damage through unlawful acts is also the ground establishment obligation. Obligations arising from unlawful acts, causing damage or tort liability. It was specifically regulated in Clause 1 Article 584 of the 2015 Vietnamese Civil Code as one of the bases for arising obligations. There are 5 conditions for civil wrongdoing to give rise to a liability, and a derivative obligation can be in the following forms. Compensation, which means compensate for damage caused by material or spirit. The act of transferring ownership of an asset to compensate for material or mental losses. Publicity apology, corrections and the violation/do not commit the violation and perform a certain job. Position of the parties in the obligation is an obligation relationship in which there are 2 or more legal entities, basically called victim and tortfeasor. Let's have a little comparison between the injured party and the party causing damage. The object of compensation must be property because the damage is of a property nature. The injured party will receive increased assets and the party causing damage will receive reduced assets. Tort law obligations arise from others' right to be free from harm. That is, an event has violated the rights of this subject and, according to the law, leads to compensation for damages outside the contract. The relationship of obligation arises when damage caused through unlawful acts occurs. Obligatory relationships arise when there is a court declaration. Article 588 Vietnamese Civil Code governs limitation period for initiating legal action claiming compensation for loss and damage. E.g. Judgment on compensation for non-contractual damages, number 25/2021/DSST. In 2019, Ms. H was driving a motorbike and collided with Mr. T, who was also driving a motorbike. The collision caused her to fall, causing a traumatic brain injury, brain hematoma, broken shoulder blade, broken left heel bone, fracture of left toe number 4. The event of Mr. T driving a motorbike without paying attention and at the same time using alcohol violated Ms. H's health, compensation for damages due to violation of health. In this case, Ms. H is the victim, Mr. T is the tortfeasor. So Mr. T must compensate Ms. H for material injury and mental injury. Specifically, the costs of treatment and rehabilitation of lost health and function, actual costs such as ambulance rental costs, neck refills, belt straps, actual cost of income, expenses due to injuries and sequelae caused by the accident. Or you can refer to Judgment 518/2020/DSPT dated June 16, 2020 regarding the request for correction, apology for more information. Last but not least is other bases as provided by law. Besides the Civil Code, the sources of obligation are also regulated by other related laws such as the Labor Code, land law, commercial law, etc., and they must not be inconsistent with the basic principles of civil law prescribed in Article 3 of the Civil Code. The provision of obligation in these other related laws shall apply in specific sectors. Clause 2 Article 5 of the Civil Code admitted that civil relations including obligation may be regulated by custom practice. Custom practices shall apply when matters are not addressed by law nor agreed by the parties, and they must not be inconsistent with the basic principles of civil law prescribed in Article 3 of the Civil Code. In many countries, precedents or court decisions containing solutions to particular issues arising from civil life are admitted as a source of law as well as obligation. In Vietnam, the process of applying precedents is still in the formation stage, and they shall apply where relations arise within the governing scope of civil law, but are not addressed by law nor agreed by the parties, and no customary practice applies. Article 6, International Treaty, is also considered. Clause 4, Article 4 of the Civil Code governs